Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm asterisk in central Minnesota. Well, I'm the actual criminal lawyer. Welcome to my show, my lair, my domain. Today was day 10 of the Karen Reed trial, and I was going to record a brand new recap for you guys, but right at the end of the show, someone asked me, they're like, hey, you're not going to do any legal analysis today. And I was like, I was trying to avoid it. But of course, I decided not to avoid it. And I thought the best way to, get this to work was just to go ahead and play the video. And you guys can have the recap that I did at the end of the video. And in the video, real quick, I just talk about what the defense's strategy is, what the prosecution's strategy is, how they're doing, in my opinion, on the witnesses that they're bringing, the testimony they're eliciting, why they need to do these things. And again, this is all just my perspective based on watching the first couple of weeks of the trial. We're well into the third week now. And this is just my kind of summary of where I think each side is in how they're doing based off of what they told us they were going to do in their opening statements and the witnesses that have been brought by the state and how the defense has countered those. So hope you enjoy it. Let's get me pulled up. Oh my God, that's a terrible pause. Don't look at it. Don't look at it. It's horrible. But here you go, guys. I'll let me take it out. Maybe. Fuck you, dude says, so no legal synopsis from the day today. I mean, I've been talking about what the strategy seems to be for both the prosecution and the defense. I talked about it with Joe, but I'll gladly just recap it real quick. My theory of the case from the prosecution right now is that the state's entire case rests on the idea that Karen Reed knows that she killed John. She's conscious of it. She acts in a way that she's conscious of it, and she says it. I don't believe that happened personally at this point. The state has not given me enough evidence to believe that. But I think the state is intent on convincing the jury that that's the truth. And I think that they are more intent on convincing the jury that that's the truth than they are proving to the jury that it happened. Is that Karen Reed believes it happened. If Karen Reed believes it happened, it's because she wanted it to happen and then it did happen. If she believes she hit him and murdered him. I hit him right after screaming at him, fuck you, I hate you, you're fucking other girls. If she believes that, then she did hit him and she did want to hit him because he's a philandering asshole or whatever. And now she's killed him with a Lexus, which is better than getting killed by a Toyota, I guess. So I think that's the state's case. And I think they're doing an okay job of at least putting that down. And I think the jury probably is taking the simple approach on the statements. And that's where they keep going back to is what did she say and how did she act? We're not getting great forensic analysis, but they don't have to have great forensic analysis. They have to have forensic analysis that is supportive of meeting the elements of the crime. And that's it. That's the limit that they need. The rest is jury manipulation. They can give a little on the forensics if they can gain a lot on the admission. This is what I was talking about again with Joe when I wasn't doing legal analysis before, but there are two aspects to the evidence that you're trying to, or the testimony you're trying to elicit out of a juror and any exhibits that you're trying to introduce. It's not just persuading the jury. We often are like, okay, how's the jury looking at this? How's the jury looking at this? How's the jury looking at this? Wildly important, yes. But the first thing the state has to do to carry on the case beyond its case in chief's closing is to actually meet the elements of the crime. So they need to bring on witnesses that have direct evidence or circumstantial evidence, if it's allowed, to actually fulfill the elements of the crimes that are that Karen Reed is accused of. And there's three of them. first one is the second-degree murder with malice. Second one would be the murder with through DUI. And then the third one would be leaving the scene of a known auto accident that you're responsible for that involved an injury or death. I think I don't remember how specific it gets, but it's somewhere down that chain. Fleeing the scene. They need to introduce evidence, even if that evidence isn't great, but admissible evidence that meets the elements of each one of these criminal acts. Because remember, the jury, once it gets to the jury's aggregating everything in their head. They're not going through and going, okay, does this piece of evidence outweigh this piece of evidence and this and this? Like they might do that on some things, but generally speaking, they're going to go, yeah, I think this bitch is guilty or not, right? Like that's going to be their first thing. And then they're going to have a discussion, try and get to, if there's someone who disagrees, like maybe they all just say guilty or not guilty and it's game over. But then they'll go through and they'll have a discussion and find out where there may be disagreement. But in general, the jury's going to be, basing their decision on those impressions that are more broad and intangible, ethereal, maybe. I don't know. I don't know if ethereal is the right word, but they want the concept. Karen Reed said she did it because she knew she did it, because she wanted to do it. They want all that in their head. That's the persuasive part. But again, before that matters, they have to get the elements in there. And that's why they may call Proctor. That's what we were discussing, is are they going to call Proctor again? If they call Proctor again, they're going to take a beating like they did last time, because cross-exam is going to just beat the hell out of him. But if he has some of the facts that are required for malice murder, like if he's the guy who put together the tire speed, for example, that suggests that the car was traveling at 24 to 27 miles an hour. If he's the only guy who's who's reconstructed that, I mean, you can disagree with it all day and be like, no, the black box is bullshit because it's the speed sensors inside the front driver's side tire. And so that thing's spinning in the snow. It's not actually, the car's not going that fast, et cetera, et cetera, et cetera. Like you can make all those arguments, but that evidence is now in there. And now you can fulfill the element of malice murder by suggesting that she was traveling at a high rate of speed intentionally when there was no need to do so, right? There's no compelling reason to do that other than to run over your boyfriend who's cheating on you, that fucker. So like that's a critical part of all these witnesses. We have to bring in the evidence. It has to be admissible, and then it has to fulfill an element of the crime. You don't get to undo it though. Like the defense doesn't get to come in and be like, aha, our evidence is better most of the time. Our evidence is better and outdoes theirs, and therefore they lose. It doesn't work that way. The defense is really just concerned about the persuasive aspect. So again, we see their strategy continuing the whole time. Make them look evasive, make them look untrustworthy, make them look connected. And they're doing great with all of this. They're showing, even they get the weather guy to be evasive on what foggy is. And like, if it's dark, if they can't see as far, it's like, well, duh. But get every witness, every single one, even the ones that are likable or whatever, to look evasive, to look like there's some level of collusion or conspiracy, and to make it look like the investigation was shoddy, maybe even intentionally so, and that the evidence that they're testifying to and that the reports that they generated are not to be trusted, because either there is a conspiracy against Karen Reed because it's a frame-up job for a death that occurred intentionally or not within the home, or they just really don't like this chick and they're really going to go after her like intentionally and more methodically. But that's like, they have to raise the specter of these sort of conspiracies or motives or whatever you want to call it without directly alleging them, so they don't have to prove them. But they want the jury to look at these things, go, here's why the evidence will be unreliable. Now look at how unreliable it is. Now remember that it's unreliable because they're trying to frame up our client. We're not going to say that, but you'll figure it out. So there, I hope that helps with the request there for a little bit of law talk on this, a legal summary, if you will. It's hard to do a legal summary on trials because a lot of this stuff there's not much legal analysis to do. There's strategy analysis. And some of that involves law and some of that involves people. But there's not like, unless there's a motion hearing and we're reading briefs and going through citations, like legal analysis, there's really balls and strikes on bringing in evidence. And a lot of the big legal analysis has happened outside of the presence of the jury. Obviously, that's not really for them to deal with at all. That's for the judge. And so there's no place for them to be there. But that happened pre-trial motions, or some of these sidebar communications that are happening. Like this morning, the judge said she needed to clear something up. Those types of things are where legal argument is happening behind the scenes that we're not necessarily privy to. But if anybody like finds those documents and wants to talk about the legal analysis and going through their motion paperwork, like we can certainly do that during some of the breaks. I'm not opposed in any way to offer my insight on it. It's just mine. We can also ask Chat GPT and they can call me stupid and I can kick my computer into the fucking oblivion. So there we go. That was my analysis, my wrap up of day 10 in the Karen Reed trial. I'll be back for day 11. Hopefully you like this little wrap up video. I know not all of you can watch 8 hours of content every single day, but if you like that analysis, that does come from me watching these live streams. Come join us on a live stream if you have the time, even if you pop in for just a little bit. Drop a like, drop some comments in the chat. Hang out with us for a few minutes during your day and have a good time. Remember how to laugh, because we're also making fun of Kurt. Because if you don't know who Kurt is, that's uncivil law, and you should come join us and find out. That being said, thanks for watching. See you next time. Peace. Peace.